Hello, this is Scott Horton. We're just starting. We'll have about 5 more minutes where people will be joining us, and then I'll get started, hopefully right at noon or just a minute or so thereafter. Thanks for joining me today. Again, we're just getting started. People are starting to get into the room. If you're here, you should see the cover slide of the presentation on your screen. If you can see the slide that says "Don't fire me on Friday," and you can hear my voice, then you are in good shape. There is also a chat window. If you find that, that's where we will be doing the question and answers later on in the webinar. Again, we still have a few minutes to go before we get started, but I welcome you that are joining a little early. I just posted in the chat, so you can test that and see if you're able to see the comments coming through on chat. Again, if you're joining us, this is Scott Horton. I'll be presenting today starting in about 5 minutes as people continue to join us. Okay, we at least have one person who's found the chat feature. Thanks. The rest of you, if you want to try that out now, you can. Most important, that's where the questions will be posted for the question and answer segment at the end of the presentation. You are streaming video here, so if you have other windows open on your computer or whatever device you are participating through, that could affect the performance and may cause lag. So it's recommended that you shut down any other applications or windows that you can. But usually people don't have too many problems with these webinars. Again, this is Scott Horton. We are scheduled to start at noon. We're just a couple of minutes away from that. I see someone has said that they have a message telling them that their video file is not found. I would suggest going out and coming back in if you have that problem. If anyone can see the slide presentation, the cover slide, "Don't fire me on Friday," with my law firm logo on it, please let me know. Okay, we have somebody who said they can see the slide. Yeah, it looks like everything is working from my end. If you can't see the slides, I can, in a moment when we get started, make available the PDF version of the slides. So that might be a workaround if you can hear me. But in the meantime, I would try logging out and logging back in once, since we still have a couple of minutes before we get started. Right now, you should see just a static slide on the screen that says "Don't fire me on Friday" and other tips for letting employees go without making big waves, with my name, the name of my law firm, and a picture of a man walking along the sea. If you can see that, then you're in good shape. You can chat, obviously, if you're asking me these questions, and hopefully you can hear me. As I just mentioned, if anyone's still having trouble seeing the slides once we get started here in a minute, then I can make available the slides. That way you'll have them in PDF format if that's better for you to follow along. Okay, it is 12 o'clock. I'm going to start in just a minute, but if there's anyone now who cannot see the cover slide, and you have already tried logging out and logging back in, please type in the chat that you cannot see the slides. Hopefully everyone else can hear me and see the slide and the chat function is working. Again, this is streaming video onto your computer, so if you have other windows or applications running, it may affect your performance on this webinar. But normally this works pretty smoothly without too much lag. So probably something on your end if there's any problems. But again, we'll do what we can to work around that. I will go ahead now and post the slide. I suggest if you can see the slides here in the webinar just fine, then you not bother to download the slides yet. I'll repost the link later. But you should be seeing a link pop up to download the slides. This way, if you need it, because you can't see through the webinar platform, you can download those in PDF format and hopefully follow along that way. But if you don't need to do that, I prefer that you stay here in the chat room. It's easier for you to follow along and then type in comments or questions if you need to. And again, I'll post the slides later. Okay, good afternoon now, everyone. This is my presentation called Don't Fire Me on Friday. My name is Scott Horton. I am an attorney and founder of Horton Law, PLLC. We just finished or celebrated our 1-year anniversary of Horton Law at the end of last week, so I'm very excited to start off on year 2. I represent employers, management, and employment issues primarily. And I tend to do these webinars not quite every month, but close to every month. So if this is your first one, thanks for joining us and stay tuned for future topics. Hopefully, many of them will be of interest to you, even if they are not all of interest. So what I wanted to do today is provide a little bit less pure legal content and get a little bit more into some of the practical aspects of my practice, in the sense that quite often I work with employers, human resources professionals, managers, business owners in situations involving letting employees go for one reason or another. Often these conversations involve me because the client is concerned that they may be doing something that could get them into trouble, not because they think they're doing anything wrong, but just because there really are so many laws out there regulating the employment relationship these days. So it's always a good idea to get some additional advice on that, especially if there is any particular reason why a situation is problematic. Yeah, there's no live video in the sense that there's nothing moving on your screen. For somebody who raised that question, it's video in the sense that there are pictures and the slide will change eventually. I'm just indicating that this is like you're watching a live video. It's just that there's nothing moving, but you're getting the audio and whatever I put on the screen as video. Okay, with that, I just want to then quickly start off with a poll question related to our topic. And you should see on your screen, or momentarily see on your screen, the question, have you ever personally fired someone? Just give us a rough idea of our audience here. Some of you are involved behind the scenes, but don't actually deliver the message. Others of you are the ones who get to bring employees in the room and let them know the decision has been made. Okay, so it looks like a little more than half of you have personally had to fire an employee. About a third of you have said no, you haven't, and then a few of you have been in the room, maybe as a witness or a second company representative to the meeting. So it's a good mix. Hopefully we can help all of you out today. Okay, now you should see a new slide on your screen for those of you who are worried about whether you have a good connection here. The slide says, I have some bad news. And the slide says, I have some bad news, not because I have bad news for you. Hopefully this is all good news and at least helpful information for you. But this is on the screen because normally when you're going to have this meeting with employees, you want to bring them in the room and from the get-go let them know that this is not going to be a comfortable meeting. The research on this subject suggests that it doesn't help to try to sugarcoat it. Once the decision has been made and you're meeting with someone for the purpose of letting them know that they will no longer be working at your company or organization, you should clue them into that from the get-go. Often the employee will know what is happening before they even come into the room, perhaps, although you don't necessarily have to broadcast that. But other times, an individual may be taken by surprise, so you should, ask them to sit down and then explain to them that you do have some bad news. Now, after letting them know that you have some bad news, there are a lot more things that you're going to be telling them in a relatively short period of time. So what we're going to do is try to walk through some do's and don'ts of the entire process. It's not going to be necessarily chronological order of exactly how you're going to conduct the meeting, and every meeting might vary depending on your situation and the reason that the employee is being let go. And our first do here is do have a good reason. I like the image on the slide here for various reasons, but for starters, let's just say you have an employee who hasn't demonstrated the knowledge of what tools to use for what different aspects of their job. That might be a good reason to let them go. But I do think you need to have a good reason going into that meeting, and the person who is communicating the termination message needs to know that reason, or at least in some terms, not necessarily in every detail. Why do you need to have a good reason? Because although virtually every part of the United States has the concept of at-will employment, you should pretty much assume it's a myth. In other words, at-will employment says throughout the United States that either party may end the employment relationship at any time with or without notice for any reason or no reason at all. However, we have all of these discrimination laws and other regulations that make it virtually mandatory these days that an employer have some good reason for letting the employee go. The only way you could avoid that requirement, I suppose, is if you legitimately had no reason whatsoever, in which case you would just be arbitrarily firing someone. So that's probably not a good business practice, even if it were legal. Because other than good reasons, there are many bad reasons under the various federal, state, and local employment discrimination laws, such as you are letting someone go because of their age or because of their race or because of a complaint that they filed, for example. So the concept is you should have a good reason. And not only should you have a good reason, but you should actually communicate that reason to the employees in that meeting in some sense. Now, I've put on this slide a number of comments that are not uncommon to be made by management in these conversations, but I do think that all of them are insufficient in most cases. For example, it's pretty typical for an employer to want to just say it isn't working out to the employee. The problem with limiting your message to it just isn't working out is that the employee can interpret that in a million different ways depending on the circumstances, and they may jump to conclusions that the reason you're getting rid of them is an inappropriate reason rather than a legitimate one. Related to that comment that it isn't working out, you often hear you're not the right fit. Again, there's a comment, while I mentioned your streaming video, there's no video, there's nothing moving. It's just the slide. There's nothing else to see. So if you're worried about me saying that there was video and you're not seeing it, then you know that it's just the slide, but technically this is video is all I was saying. So it is streaming, so if you do get a glitch or a lag, that's all I was referencing. Okay, moving along. So similar comments, we have someone else in mind, you should have known, and particularly something like the last one here, this is hard for all of us, you know, are really just ways of trying to avoid looking like you're the bad guy, I suppose. You know, it doesn't normally help to tell somebody this is hard for all of us because the person telling them that still has a job tomorrow and they don't. So with all of this in mind, you should really go in letting them know we have some bad news, we're going to have to let you go, or better yet, conveying the fact that you've already terminated their employment, because by this point it's not up for debate. And then go into some description of why. In other words, what you did last week was just totally unacceptable, or your performance has been slipping for months now, or we've decided to eliminate your position. And again, you don't have to break that down into too much detail, and you certainly don't want to debate it with the employees, but you should have some message beyond those on the screen. As I just mentioned, we don't want to leave room for debate in the termination meeting. This is not a boxing match or a volleyball game. It's not going back and forth. This is primarily a one-sided conversation. Whoever is presenting the message for the company or organization needs to keep control. The one piece of advice I tend to give clients most often is to advise the employee that the decision is final. Use those words because it's common for someone to want to nitpick aspects of their performance or beg for another chance, etc. And the fact that they don't agree with the decision at this point is pretty much irrelevant. Now, I suppose there might be an exception made after the fact if something new comes to light, but I wouldn't use that possibility as a reason not to confirm that the decision is final. If you say the decision is final and for whatever reason the company later changes their mind and brings the employee back, then so be it. The employee is not going to further complain that they were told the decision is final when it turned out that it wasn't. But in most of these cases, the decision will be final. Don't entertain the confrontation. If someone becomes at all belligerent or whatever, and you had more to say, it's perfectly acceptable to end the meeting and then escort the person out. In rare cases, you may even have to call for help to do that. Normally, people don't become violent in termination meetings. But if they won't let you talk, then you don't have to sit there and just read your script while they are screaming at you. You can always find another way to confirm to them that they should not report tomorrow, and if they do, they won't be allowed in. Finally, of course, you always want to have a witness present, especially if there is debate that starts. Ideally, that witness will help you keep control, but otherwise they should preferably be taking notes so there's a record of what did happen in that meeting in case the employee later comes back and says, well, you told me in that meeting that the reason you were letting me go was X, Y, and Z. You have some record that contradicts that or confirms it, but maybe in more detail, etc. So I don't think anybody's surprised by that advice to have a witness present. Occasionally it may not be possible, but even if you end up having to fire someone over the telephone, for example, try using speakerphone so you can have someone else in the office to hear everything that is communicated. Again, I'll just remind you at this point, there will be a question and answer period at the end. I'm hoping to allow plenty of time for that. I will stay on as long as there are questions, but I'll try to get to that well in advance of 1 o'clock for those of you who have only an hour for this webinar. So the next do is notify them in person. I just mentioned telephone. That should not be the preference in most cases. It is better to talk to someone face-to-face in this situation. And when I say better, I mean the outcome of the process tends to be better, not necessarily easier for either you having to give the message or for the employee having to hear it. But there are a lot of reasons why notifying someone of their termination in person should be the preferred approach. I just chose this picture on the idea that we're so used to hiding behind screens these days that there's concern that people are less used to having face-to-face meetings, even when they are sitting at the same table, for example. So I realize this will be out of the comfort zone for some of you in some cases, but it really does help the process go smoother. Now, there are some times when you won't be able to have an in-person termination meeting. For example, meeting in person just isn't possible because, for example, the person is incarcerated, and that does happen. I have certainly advised clients who can't speak in person with their employee because that person is behind bars. There have also been cases where someone has been in the hospital, for example, which is not necessarily the right situation to fire most employees, but there are some cases where it nonetheless has to be done at that point. I would not generally recommend going to someone's hospital bed to let them know that they no longer have a job. Then there are the cases where there is some heightened security concern. I told you before, and in my experience, it's true that most people don't become violent when they're told that they've been fired, but there may be some people who you have some concerns about. So if you have an employee, for example, who was involved in several physical altercations with coworkers, and that's the reason that they're being let go, you might consider not meeting with them in person, or you might consider taking some additional safety precautions, like having additional personnel on hand In rare cases, maybe security guards, even in the room, sometimes possibly even put the police on notice, but for the run-of-the-mill case, that's not a problem. You've got the no call, no show situations. Some employee hasn't shown up for a week, so you're formally letting them go, but that you've tried calling them as it is and you can't reach them. So, at some point, you're not going to wait until you see them before you fire them. You're just going to have to send them a letter. Occasionally, an employee will just refuse to come in. By that point, they know what the message is, and they just aren't cooperating. So, you can only do what you can do there. And there will be other cases where time is simply of the essence. And here I'm thinking, for example, of perhaps an employee who's traveling for business, but there's some compelling reason why you have to let them go immediately. Perhaps you found out they've been stealing from the company and now they're about to go into a major business meeting with a key client or customer somewhere in a different part of the state or country, but you no longer want them representing the company starting immediately. I mean, you're going to have to get on the phone or send a message or do whatever it takes for the message to be received as soon as possible in some cases. But even in those cases, you may be able to then have a follow-up face-to-face meeting. Again, if you have questions, you can type them in at any time, but I will probably save them until the end of the presentation. But if it helps you to go ahead and type them in so you don't forget, that is fine with me. I did call this webinar Don't Fire Me on Friday, just to sort of catch your attention about the topic. That is one of my standard pieces of advice. It is not an absolute rule. There's no law, of course, saying you can't fire anyone on Friday or any other particular day of the week. It's just advice that comes up again and again in conversations, because historically, I think there has been a notion that it's better to fire someone on Friday at the end of the week, and that makes things easier. But for a lot of reasons, it probably doesn't. Most notably, it tends to ruin everyone's weekend because you don't like firing people. So is that really what you want to do Friday afternoon when you're thinking about, spending time with your family or reading your favorite book or going hiking or whatever it is you like to do on your time off? But the other logistical issue with firing people on Friday is that many resources that are available to a fired employee during the week are not as readily available on the weekend. That's a little less the case these days with the internet and all the other access channels to information and communication. But still, many professionals, attorneys, psychologists, even doctors are not going to be as readily available on the weekend as they would be, say, on Thursday. The big problem with that is an employee who is fired may have a lot of things they need to worry about. They may need to reach out to a financial planner, for example, in some cases. That person probably isn't going to be available to them on Monday, until Monday. So, if possible, for a lot of reasons, it's better not to send them out the door with nowhere to turn for a couple of more days. Because what you would ideally like as a company or business letting someone go is that they will have somewhere else to go, so that they don't just sit around and stew about losing their job and then think about ways they can get back at the company that just fired them. Lawsuits, for example, or just meddling with customer relationships or bothering employees. So, the sign that was on the previous screen actually went on to say, when one door closes, another opens. All you have to do is walk in. Well, it's easier for them to walk in somewhere when everything is not closed. So especially if you're in the type of business that is normally Monday through Friday, then they may not be able to reach out to the company to ask questions, and they may not be able to reach out to future employers or the unemployment office until Monday. So there's some reasons from the employee standpoint. There's also reasons from your business's standpoint. Again, you don't want to ruin your weekend. If you were planning to be off Saturday and Sunday, you have to fire somebody Friday afternoon. What logistical issues is that going to create for you? Do you have to find a temp to be there Monday morning? Is it that critical of a job? Do you have to make sure you have that person's computer back immediately? Do you have to go through it and their files? So if you do this on Tuesday, then it's easier to go to work as normal on Wednesday. So again, are you open tomorrow? Maybe a different situation if the employee's shift is, I don't know, Thursday to Monday. Then, you might not consider Friday the end of your week, and it doesn't make as big of a difference for your organization. But again, think about their access to other resources over the weekend. And then there's also the aspect of dealing with customers and vendors, et cetera, who may have been in touch with the employee. If your customers aren't going to be sitting at their desk until Monday morning, and it's important that you reach them to let them know that their account manager is no longer with the organization. Again, easier to do that in the middle of the week. Excuse me. So again, don't fire me on Friday. It's not an absolute rule, but it is something to keep in mind. Certainly there are situations where someone has just done something so egregious that you have to get rid of them immediately. If that happens on Friday, then you're going to do it on Friday, or at least send them home on Friday and bring them back on Monday to formally terminate them. And at that point, they already know that they're not going to continue working there. You have to do what's best for your organization, obviously, but if all else is equal, aim for the middle of the week. Do preserve the employee's computer. So obviously there are still many jobs that don't involve the use of a computer, and this isn't as important for those, but they may still have email access, where they can, even if it's logging in through a computer station at work, for example, that you would have to tie down their email account. But for many employees, they do actually have a laptop that they take home with them, maybe a tablet device, a smartphone, a physical desktop computer. When you bring them into the termination meeting, you want someone else in the organization to be cutting them off from their access to that. They may still have the smartphone in their pocket at the moment. So, you don't want them reaching in their pocket and frantically forwarding everything, all the company information, off to a personal account, for example. So ideally, you have that access cut off pretty quickly. The next step then is, during the meeting, you want to start the process of getting the property back from them. If they have the smartphone in their pocket, you ask for the smartphone, and they can be expected to hand it over to you immediately, because it's the company's property. Now, there may be issues that need to be worked out. Who gets the phone number? Do they have files on it that they need? And you can work that out after the fact. You're not going to be unreasonable about it, but you have the right to secure your property or your company's property. So you get all that back as soon as possible. The laptop might be at home, and you have to make arrangements to get that. Again, any remote access you can cut off is important, but it's still going to be possible they could do something between the time they know they've been fired and the time you get the information or hardware back. So one thing you might want to consider is copying whatever they do return. This could mean copy their files on their desktop that's already just still sitting in the office. It could mean copying the hard drive of their laptop that they return, etc. When I say copy here, I'm ideally thinking about actually getting a forensic image made of the hard drive, for example, by which I mean everything copied, all the metadata, all the way back into the background details of the device, such that if there were some reason that someone needed to, an expert could go in and find out exactly what the user, for example, the now fired employee, had done on the devices. This could become important if there's any risk of a trade secret theft or breach of a confidentiality agreement, something like that. The possibility that this employee was already planning to go work for a competitor in some cases. So, you have to gauge the situation. There's some cost and hassle involved, but it can be valuable to make that copy, which you can then set on a shelf for evidentiary purposes down the road, on the assumption that whatever they return, you may need to also go through, but you don't want to go through the only copy because then you will upset the evidentiary value, change the metadata, etc. But certainly once you get all of this information back and preserve whatever you need to preserve, you probably will want to go in and at least look around and see what the employee's been doing, making sure they didn't do anything untoward just based on your review, and also because you may need some of their files. They may have projects they were working on where there's files available on their devices, and you want to get those and transition them over to whoever's going to do the work going forward. I kind of alluded to this a minute ago. You want to lock this down and secure your business and your files and your data, but at the same time, you don't want to ignore reasonable requests. You're probably wondering, what is this picture on your screen? This is something my daughter created in a few minutes on my work computer, admittedly. So the reason I put this up here is, you can certainly have a situation where the employee has had something on their work device that is personal in nature and they want it back. I mean, I suppose you could say, well, we told you up front that this was for business use only, but in the run-of-the-mill case, why would you go out of your way to upset someone who you've just fired? You probably want to transition them out as pleasantly as possible. So if they want the pictures that their kid gave them and sent them on their, smartphone that they were using for work, then find a way to get that back to them. But it doesn't mean you have to give them unfettered access to their laptop until they're satisfied that they have everything they want off of it. So you'll have to work that out. Because you're going to expect questions both in the meeting and to follow up after they've been informed of the termination and sent home. Perfectly normal. They might ask, is today my last day? I recommend that usually if you're firing someone that it is their last day. It usually doesn't work to say, I have some bad news for you. We've decided we have to let you go, but we want you to hang around for another week to help us out, transition your files, etc. It normally doesn't work very well at that point, but there may be exceptions and there may be reasons why they're going to stay on. You probably have already told them that before they even get to ask questions, but anticipate that possibility if you're not making it clear. When will I receive my last paycheck? That's something you should be explaining. Every state has different requirements, so make sure you're doing it in a timely manner. In a couple of states, you actually have to provide the final paycheck at the time and place of the termination. In New York, where I think most of you are located, you normally just have to pay by the next pay date. Questions about unemployment insurance, that might come up. References, what are you going to tell others? And there are not any necessarily right or wrong answers to these questions. There are just things that you should think about going into the meeting. But it also is not the case that you have to have an answer for every question that the employee might ask in the termination meeting itself. You just have to be ready for questions. Again, you don't want to get into a debate, and it's perfectly acceptable to say, I'll have to get back to you on that. But what you don't want to say is, look, I'm doing all the talking here. I'm going to give you the information you need, and then you're going to leave and we're going to be done. I mean, you certainly want to leave the line of communication open with reasonable parameters. When can I get all my personal things? In some cases, you will actually give the person the opportunity to walk out and clean off their desk. Other cases, it may be better to arrange to have that done later when other people aren't, working around them, where it might cause embarrassment. Some people might want to say goodbye. Others want to slip out the back. Then it's just questions you're going to have to think about in your situation. If you have to take a break from the meeting and go double check with someone immediately about how you're going to handle a couple of these things, that's fine too, especially if you have a witness in the room. Maybe you can let them run do it. You probably don't want to leave someone completely unsupervised after you've just told them that they're fired in most cases. There'll be some benefit issues too. In the termination meeting itself, you may want to go over some of this, especially if you're going to offer a severance package, in which case you might specifically go through the severance package, or you might just reference that you're going to be mailing them some information about a severance package. Some of the issues might be more pressing, and you might know a little bit more about the individual employee involved. For somebody, the status of their health insurance might be a major concern. And that could be something that needs to be addressed pretty quickly. Other questions like what's going to happen for this year's profit sharing bonus usually can wait a little longer, but again, should be addressed and responded to in a reasonable amount of time. And for that purpose, you always want to provide a contact person to the individual, whether it's you or someone else in the organization. Let them know, if you do have any questions after you go home and let this sink in, then this is the person that you call. And in some cases, it'll definitely be better to minimize how much additional information you go through in the termination meeting and just try to defer toward questions after the fact. But again, make sure you do follow up with anything that has been asked, and there's some obligations that you have. For example, COBRA documentation has to be mailed out within certain time period. There could be various state laws that require additional notices. New York law for private sector employers anyway requires the company to send or provide in writing a notice of termination confirming the termination date and the status of various employee benefits. Sometimes that's as simple as this will confirm that you've been terminated on date X, and as of today, you are no longer eligible for any benefit provided by the company. Other times it'll have to be information about converting life insurance, the health insurance information, such as COBRA documentation. There might be profit sharing and 401k information, etc. If you are offering a severance package, either by existing policy or based on the circumstances, then there might be some back and forth negotiation over terms. You, as the person conducting the termination meeting, might not be the person that ultimately makes the call on those negotiations. You might get an attorney involved, or there might be somebody else within the organization that handles that. Again, it's just a matter of putting the employee in touch with the right people so that you can get everything taken care of, ideally as soon as possibly, but most importantly with as little friction as there can be. That being said, especially if there is a severance payment involved, you should consider getting a release. This picture is someone about to let go this salmon. Looks like a perfectly good salmon to me, but if you're letting someone go, especially if there's any reason why you have concern that they might come back after the company for something, or there's some dispute over anything. You might consider getting a release for which the company will have to provide some form of severance, whether it be a cash payment, a health insurance continuation, providing outplacement services, or some other benefit. If you're going to get a release, you want to do some things to make sure it's enforceable. You hand somebody a piece of paper in the termination meeting and say, sign away all your right and everything that you might possibly have any claims against the company, and you have to sign in the next 30 seconds or else. And you wouldn't want to count on that ever being enforced in the court. Recommendations include using an explanatory cover letter, going over what they're getting and what they need to do, time periods, etc. Address any outstanding issues if there is specifically a dispute over a bonus payment, for example, or if there's some property that the employee still needs to return but can't do so immediately, you can include that in the release and severance documents. You want to allow them some time, by which I mean number of days, to review the document before they sign. Again, if you tell them sign now or else, there's a real risk of non-enforcement. You should expect them to meet with an attorney. Not really fair to give somebody a release document and just say, no, you can't meet with your lawyer. The Older Workers Benefit Protection Act actually spells out some real details on a lot of these issues. It is specifically tied to the Age Discrimination Employment Act, which is the federal age discrimination law. So if you want to waive claims of age discrimination under that law for employees 40 years or older, you have to comply with the requirements on the screen. For employees under the age of 40, or for organizations that may not be subject to the ADEA, which would be those with under 20 employees, you don't technically have to comply with all of these requirements, but they are a good guideline to use even in those circumstances, because if you comply with all of these requirements as set forth by Congress for their federal age discrimination law, you probably have a pretty good argument of getting the release enforced for other employment-based claims in state or federal courts. So a couple of things you'll notice here is you do have to advise the employee to consult with an attorney. They don't have to do it. You just need to sort of recommend or encourage them in writing to do so. You have to allow them at least 21 days to consider the release agreement, and then once they sign it, they have to have at least 7 days to nonetheless revoke it. In the case where you have group termination programs, so voluntary resignation incentive programs, or a situation where you are terminating a whole department of employees but offering severance pay if they sign a release, there are some additional requirements. For example, the 21-day consideration period jumps to a 45-day consideration period. And in either case, they can sign sooner. They can sign the same day or the next day or what have you. But if they want to take up to the 21 or 45 days respectively, and you don't allow it, but they nonetheless sign the agreement, then they can argue against it. It's a good idea to keep those concepts in mind, even if you're not formally complying with the Older Workers Benefit Protection Act in all respects. And for the most part, people ask me, well, can I tell them they have to sign by Friday or whatever? Well, you might be able to if you're not worried about the age discrimination claims, if it's a younger employee, for example. But there's not always a real incentive to limit their time. I mean, if you want the release, then ideally you should want it next week just as well as you want it this week. But if there's some, financial reason why you need to know whether you're paying that severance, then I suppose sometimes you might be able to do it quicker, but never a take it or leave it situation. Don't repeat the same mistakes. We'll go through this quickly. You don't want to have Groundhog Day with your employees, meaning the movie, of course. So you want to think about in every case what went wrong, and you may or may not be the only person thinking about this. You might need to involve other stakeholders, other managers, executives, what have you. But this is the good opportunity to do it every time someone is let go. Should you restructure the position? Were we just demanding more than somebody could really handle? Do we need to change the hiring process? Did we, not weed out the right people in some identifiable way? Or should we have considered more candidates? Were we too quick to accept the recommendation of one of our managers for somebody who turned out to be his buddy, for example? Did we hire well? Do we have the right position? But it turns out we should have provided more training along the way. We can't really expect to bring on somebody who knows exactly how our business operates. So we need to either do a formal training program or beef up what we have in place or do more on-the-job training, etc. Is part of the problem the supervision? Do we not have the right people overseeing this position so that it's hard for anyone to succeed? Is the person who's currently the supervisor really the person that should be doing the job that we just let somebody go in? Are they better at making the widget than they are at helping someone else learn how to make the widget? Maybe that's how you fill that position, and then you have a new position that you're looking to fill in management. Of course, it's certainly possible that sometimes you just don't have the right person. Things come up, people change, things happen in their lives, and that may not necessitate reworking your organization or your procedures. But there are many times when it's not number 5 on this list, when one of these other areas could be improved and increase the chance that you won't have to be in the same position with this employee position. Okay, I got through everything. This is not going to be a hard sell. I just want to let everybody know before we go into questions that I do have a book now available on Amazon. It's called New York Management Law, The Practical Guide to Employment Law for Business Owners and Managers. A lot of what I talked about here comes from part of one of the chapters in the book, and there are a lot of other topics covered from the beginning to the end of the employment relationship. So if you would be interested in additional resources, this is a over 200-page book with some helpful appendices, an employment law dictionary, some different resources that you can use on a quick reference basis. But most importantly, the bulk of the book is, just narrative, written description of important employment law issues that is designed to be readable. It's not just a huge book that sits on your bookshelf with every law reference in it. It's something that managers, HR professionals, business owners can actually read probably within a few hours or less and get a good background so they at least know some of the issues that they don't already know that they exist, and then know where to look. The book is available both on Kindle, ebook version, and in paperback. The paperback is available, but because it's a physical copy, does have some printing cost and whatever. So I can't do too much on the price for you on that one, but I will give you a link here. Right now, the ebook is available for a very low introductory price for the value that it provides. Kind of unusual for this type of legal reference material to be priced so low. So if you want to take advantage of that, you can click there to get the Kindle version right now. As an extra bonus, if you do get the Kindle version, but would also like to have the hard copy, if you send me your receipt or some something from Amazon showing that you got the book, take off whatever information, blackout or whatever, any credit card information or whatever. If you just show me you bought the ebook and give me a copy of, or give me your address, then I will send you a hard copy when I get my shipment in. Some of you may have already received or signed up to receive a free copy through an earlier arrangement that I had. So if that's the case, then that will be coming out to you as well. So thanks for letting me share that. Just excited to have, an actual book out there, and I think it would help you out. But now, without further ado, we will get to the all-important question and answer period. It's 10 minutes to 1. Like I said, I will stay until you run out of questions, but we have plenty of time, even for those of you who are just allocating an hour for this webinar. So use the chat feature to type in your questions. Anything related to firing employees, letting employees go, whether I touched on it or not, certainly welcome. I just throw out the disclaimer, of course, that even if you happen to be one of my current clients, there's no attorney-client relationship in this forum. I am not providing legal advice. Technically, this is for informational purposes only, because I don't have access to all of the circumstances that you might be facing in a particular situation. So keep that in mind. Great. Here's a question that says, what is my take on a 90-day probationary period? It is pretty common for companies to have probationary periods. In some situations, they're imposed by a collective bargaining agreement with a union, in which case they can be very valuable and relevant. Separate question of whether and how I would negotiate them in the first place, but if they're there, then you definitely want to take advantage of them to the extent that they allow you the opportunity to get rid of someone with a lower evidentiary burden during the probationary period than having to prove just cause and potentially go to arbitration after the probationary period. In the public sector, there are often laws that regulate that as well. In the normal private sector business situation, I don't find a lot of value if it's not negotiated with a union and you otherwise have at-will employees. I don't find a lot of value in having a probationary period, because they're at will during the probationary period just the same as they are after the probationary period, and you should be able to let them go for any reason or no reason, as long as it's not a discriminatory reason. Presumably, if you let someone go in a probationary period, you're going to have some good reason for doing so, just as you would if it's after the end of the probationary period. Legally, I don't think it makes any difference whether you have it or not. If anything, it should be more of a device for management to use to make sure they actually are evaluating people early in their employment before you get too far along. But if used incorrectly, it could possibly backfire, especially if your policy is not written properly, to where someone might have a reasonable argument that if you don't let them go within the probationary period, that you should have a higher burden of getting rid of them after the probationary period. For the most part, again, it's not going to matter unless there's a discrimination claim. Or unless they have an employment contract with some sort of just cause protection. The follow-up questions here, I'm just trying to look at. Can you terminate within 90 days by saying they have not passed the period, or do you need documentation? I mean, again, the standard, assuming at-will employment, which unless you have a union or an employment contract with them, there should be at-will employment. The standards really have you discriminated based on race, sex, age, or any of the various other protected categories. If you've done that within 90 days it's just as bad as if you've done it beyond 90 days. Here's another question. What if you hire an individual and realize within a few days they're not qualified for the job? Can we just terminate? I mean, the practical answer to that is the quicker you get rid of someone into their employment, the less likely they are to have a valid claim against the company, or at least one that there's going to be any material remedy for. If you fire someone after 3 days, even if they can make some sort of argument of discrimination, unless it's really egregious, they're really not going to be able to recover that much. They're not going to have a very compelling case. That's not to say that I'm encouraging anyone to discriminate, within the first week of employment or anything. But if someone within a few days just isn't qualified, then you're probably pretty safe in most cases to let them go. But again, you're letting them go for a good reason, that they're not qualified for the job. The one caveat on that is if you have done something to hire them away from another job and sort of made any promises, or your offer letter suggests this or that, or you've induced somebody to move from another state and then you let them go immediately. I mean, they might have some sort of contractual or quasi-contractual type of claim saying, you caused me to leave my other job on the implied promise that you were going to employ me, and now basically all you've done is paid me for 3 days work so that I would quit working for this other company, and lo and behold, that's your competitor. I mean, you couldn't just have a process of doing that to try to sabotage your competitors, for example. So these are very good questions. Does anybody have any other questions at this point? Or if you feel I didn't exactly answer your question, let me know that and I will talk more. And also, I'll just throw this out there for those of you who are still with me, please anytime contact me and let me know what you'd be interested in me presenting in a later webinar. Put this slide up with my contact information on it in case you don't already have it. Again, I do these almost every month. I give myself a break every few months, but if there's something you want to hear me talk about, again, it can't just be your nuanced employee situation, but something of general interest, then happy to try to work something in. Again, we try to do a mix of updates on new laws, reminders about old laws, some general topics. Here's a suggestion: hourly timekeeping policies and issues. We can certainly look into working on something for that, so I appreciate that suggestion. But yeah, if anytime there's something new out there, I also try to publish multiple articles a week on my blog. So, if you get the book and you find something in there and you're wondering if there have been any developments on it, you may want to check my blog on my website, because there isn't too much going on that I don't get around to publishing about or posting about pretty quickly. All right, I'll give it another minute or two here. We're coming up on 1 o'clock, so it looks like our timing has been good. If anybody has another question, I'd be happy to address it. All right, well, I hope if there's no more questions that everyone found this interesting and helpful. Some of this you probably already had in mind. Maybe there were some takeaways that you'll be able to implement if and when you find yourself in this unpleasant situation again, I just close by reminding you that as unpleasant as it may be for you to have to deliver this message, if you're delivering the message, that probably means that you will still have a job tomorrow and the person you're speaking to won't. So the more you can do to make that transition out as um, friendly as possible, probably to your benefit, their benefit, and the benefit of your organization. But at the end of the day, obviously, you have obligations to your company that would take some precedent. That includes not doing anything that will increase the likelihood that the fired employee will go towards making claims or beginning litigation or interrupting the business operations of their former employer. So if there are no further questions, again, I am Scott Horton. I've been very happy to speak with you all today, and I look forward to the next time I get to present some more helpful information to you. Thanks very much for attending.